Yes, sir, we can go ahead. It is recording properly. Thank you, sir. Sir, Prabhakar, sir, please check.
Very good. Okay. Any questions regarding the previous classes? Now I will clear and then go ahead with the suspensions. You can carry on your questions, please, so that I will clear all your doubts. Any doubts? No doubt. I will take it for granted that there is no doubt. Okay. Okay. Anyway, one participant in the last class has phoned up to me and asked whether fact-finding inquiry can be conducted in the middle of the DR inquiry. This is actually one of the funniest thing. See, before issuing of the charge sheet, fact-finding inquiry has to be conducted. Then after getting the complete picture that the employee at prima facie has committed the mistake, committed the misconduct, then charge sheet has to be given, DR inquiry has to be conducted. In the course of the DR inquiry, conducting of fact-finding inquiry is not as per the rule. There is no provision for that. And employee need not attend fact-finding inquiry for such cases. Okay, this is clear? Right. Now, we will go for suspensions, our today's class. See, normally, all employees are under the impression that suspension is a penalty. So first I will clear that doubt. Please note that and also underline that suspension is not a penalty. See, all penalties, 9 penalties, major and minor penalties are listed in rule number 6 of D and AR. So those penalties which are listed in rule number 6 of D and AR are the only penalties. Suspension is not listed as penalty either in the minor penalty list or major penalty list. Therefore, suspension is not a penalty. Yes, somebody was asking something.
सॉरी सर, गुड इवनिंग।
Very good
सर
evening.
ये सस्पेंशन के बाद जो किसी भी एक्यूज्ड को रिवॉक किया जाता है तो वो अपना छुट्टी लेता है, एलएपी या जो भी छुट्टी लेना होता है, तो इसके रिगार्डिंग क्या रूल है? जब सस्पेंशन पेनल्टी नहीं है तो व्हाई ही विल अवेल हिज ऑन लीव? वो डिपार्टमेंट अगर मान लीजिए उसमें कोई चार्जशीट इशू नहीं कर पाती है या कुछ नहीं उसमें होता है तो पार्टी इसमें क्लेम कर सकता है ना, क्योंकि तो एडमिनिस्ट्रेटिव पार्ट है। तो इसके बारे में थोड़ा बता दें।
See, suspension is not a penalty. Now, if you hear my complete class, you will understand. Anyway, you have raised this question, all right. See, during the period of suspension, you need not avail any leave. You can take permission to leave headquarters and then go complete your work and come back. Leave will not be marked. Leave should not be marked rather. No sick, no leave, no LAP should be given or can be given and should be asked even. Only permission to leave headquarters has to be obtained. Because as per the rules, you are not supposed to leave the headquarters during the period of suspension. So when such is the case, if you want to attend your own works, you take permission to leave headquarters and then complete your work and come back. There is no leave thing. Leave you need not take. They will give leave. Unnecessarily your leave will go waste because leave cannot be marked while suspension. Sick also can, because now we will come to the part of sick. You are actually sick. Then what to do? Then doctor has to be called. Doctor has to be called to the workplace and then he has to be examined there. If required, you can take him to hospital also. So that period will be treated as sick only. Now, suspension only, not either sick or leave. There is no provision for granting leave. Leave will not be granted and leave you should not ask also. And it will be waste only if you ask your leave. You unnecessarily you will be your leave.
सॉरी सर, मेरा प्रश्न है कि रिवोकेशन के बाद का जो सस्पेंशन पीरियड है, 3 दिन, 4 दिन, 10 दिन, 20 दिन, जितने दिन का, उस पीरियड का जो सैलरी चार्ज हो रहा, उसमें
yes,
पार्टी
I will come to your point. See, as per rules, the suspension has to be followed by only major penalty charge memorandum. Suspension period has to be followed by major penalty charge memorandum only. Okay. Now, what happens? Some DS, what they are doing, they will revoke, they will complete DR action for any reason. Suspended employee is given minor penalty charge memorandum. Then the complete period of suspension has to be treated as on duty. Please note it. Minor penalty charge memorandum दे दिया समझो. So complete period of suspension को duty करके समझना, leave करके नहीं mark करना. Number 1. Now major penalty is issued. Then DA has to spell out while giving speaking orders how the period of suspension has to be treated. Whether the suspension period has to be treated leave, suspension period has to be treated as suspension only, or suspension period is treated as to be duty, or suspension period has to be treated as leave without pay or anything, whatever may be, that he has to spell out whenever major penalty charge sheet is issued and major penalty is imposed. Kindly note, major penalty is imposed. Even after giving major penalty charge memorandum, if minor penalty is imposed, then also the suspension period has to be treated as on duty. Kindly note it. You can challenge this. You can get it converted as on duty. आपका doubt clear हो क्या जी? Somebody asked a question. The doubt is cleared.
Abhishek.
क्लियर सर.
Abhishek.
So minor penalty charge sheet दिया तो suspension period को on duty. Major penalty दे के minor penalty दिया तो suspension period has to be treated as on duty. Only if major penalty is imposed, then DA has powers to to treat the suspension period as leave, on duty, or even suspension only.
सर इशूड चार्जशीट में अगर सीओ जो है वो एडजॉनरेट हो जाता है, इंक्वायरी के बाद एडजॉनरेट हो जाता है, या चार्ज उस पर फ्रेम नहीं हो पाता है, तो वो सस्पेंशन पीरियड को क्या चैलेंज कर सकता है कि उस पीरियड को
suspension period to be treated as on duty? That complete period of suspension to be treated as on duty. In Hubli division, one of OS was suspended. He was given major penalty charge sheet. Charges could not be proved. Exonerated. The complete period of suspension was treated as on duty, and he got arrears also for that. Followed?
Thank you, sir. Thank you.
Okay. Any other doubt? Okay.
No, sir. Thank you.
Okay. Now, why the employee is suspended? First, I told that suspension is not a punishment. It is not listed in the penalty list. The penalties available in rule number 6. Hence, the suspension is not a penalty. That's one doubt is clear. That is there in everybody's mind. So kindly delete that. So you can refresh it. Now suspension is not a penalty. Then why the suspension will be imposed? Why the employee is kept under suspension or will be kept under suspension? The main thing, the main purpose behind suspension is that if the employee commits a mistake, or if there is any contemplation of DR inquiry, DR proceedings against the employee, and if there is any doubt to DA that if this employee continues in service, he may tamper the records, he may tamper the evidence. Therefore, to keep him away from the records, to keep him away from the touching of the available records, evidences, so he will be kept under suspension. Other than that, nothing. If it is interest against the safety, then he will be kept under suspension. Only to keep him away from the office work, only to keep him away from the touching of the official records, he will be kept away from the duty, so that he will not come and touch the records and spoil the evidence against him. So the employee can easily carry out the, that means employee in the sense the people who have been appointed to conduct fact and inquiry, they may carry out their investigation or their trials freely, so without any problem. Therefore, the employee will be kept under suspension. And there is no specific definition for suspension. Suspension means keeping employee away from actual work. That's all. He will be kept away from his actual work, and he need not touch any records. He need not touch any records. One very good example I will tell you here.
Excuse me, sir.
One station. Yes, please.
How long an employee can be kept under suspension?
See, an employee can be kept under suspension for any period. But after 90 days, a committee has to be appointed, and then they have to decide whether the particular employee, the suspension of the employee has to be continued or not. If the employee suspension has to be continued on the delayed tactics of the employee, then the amount what is going to be paid, that is subsistence allowance, will be reduced. And if the delay caused is due to the administration, the subsistence allowance will be increased. That all depends upon the case to case. And also it all depends upon the disciplinary authority. In any manner, the suspension should not exceed more than 90 days. Any other doubt?
Maximum how many days?
Maximum 90 days. And sometimes
Maximum
if criminal
after
see, I will tell you, maximum 90 days. And if any criminal case is there, then they will keep him under suspension till the completion of the DR inquiry. Till the completion of the D and AR inquiry. And he has to attend the DR inquiry during suspension only.
If
But
the DR inquiry is more than 180 days, so it will be treated as a
more than a suspension only has to attend. But subsistence allowance you will get free, the full. Why to worry? You need not worry. You will be getting, without working, you will get full amount, full salary. Subsistence allowance will be increased if the suspension period, extension of suspension period is on administrative account. If the extension of this suspension period is on administrative account, you will get full salary. You will be happy. Without working, you will be getting full salary. Don't worry. Any problem?
No, sir.
That's all. Till the completion of your DR inquiry, you may be kept under suspension. Hello? Unable to hear? Okay. Now, you know what is suspension. Suspension means keeping employee away from his work, actual work. The reason for suspension is he may tamper. They assume that he may tamper the records, evidence available against him. Therefore, he will be kept under suspension. Finish it. Next, what are the types of suspensions? Normal suspension. One is normal suspension. Why employee will be suspended? I told. One is he may tamper the records, or he may not allow others, and he will be quarreling with others, and he may not allow, and he may be against the safety. For all these things, he will be suspended. That's one thing. Then there is one term called deemed suspension. So for this suspension, before this, I will tell you one thing. Suspension will be issued in the format number 1, SF1. Standard forum number 1 will be issued for this to the suspended employee. Through it will be conveyed to the suspended employee through standard forum number 1. There are so many forms, no, as we discussed something, I don't know whether I've discussed or not, but there are so many forms. Among that, first form is standard form number 1, which says that employee is under suspension. The reason, of course, reasons need not be mentioned in the form. Simply they say that so and so employee is kept under suspension from pay and duty from so and so date. That is the form number 1, SF1. So then we will come to deemed suspension. So deemed suspension will be issued in through form number 2, SF2. SF2 will be issued for deemed suspension. Okay. Then under what all the conditions this deemed suspension will be issued? Here, this is more important. Many people may not know this. So what is deemed suspension? And under what are all the situations the employee will be kept under deemed suspension? So normally deemed suspension is whenever any employee is under police custody for more than 48 hours. If an employee is under police custody for more than 48 hours, then it is deemed that he is under deemed suspension. And it will be conveyed to that employee through SF2, standard form number 2. Then, second situation, if any employee is convicted and imposed an imprisonment which is exceeding more than 48 hours, if any penalty is imposed, convicted and imprisonment of more than 48 hours is imposed, then also that period is treated, that employee is treated as under deemed suspension. Then when the during the DR inquiry, the penalty imposed, either this compulsory retirement, removal, or dismissal imposed by DA or confirmed by AA, if it is set aside either by DA or RA and case is referred back to the case is referred back to the DA for further inquiry. If before the imposition of the penalty, if that employee were on suspension, then it is deemed that he will continue in suspension till the completion of the DR proceedings, further DR proceedings. Follow this point. See, this point is employee before imposing the penalty, he was under suspension. Inquiry was completed. A penalty of compulsory retirement or removal or dismissal was imposed. Then either AA or RA has set aside the penalty and case file was reverted back to DA to conduct further de novo inquiry. Then under such circumstances, the CE, the charged employee, would deem to be under suspension. You will not pick up duty, you will not be given duty. Followed? This is one case. And in the same manner, if court has set aside the penalty, then here during departmental, RA has set aside or DA has set aside. And here AA has confirmed the penalty, RA also has confirmed the penalty. And charged employee has gone to the CAT, Central Administrative Tribunal. There, the court has set aside the penalty and given this thing, authority to DA to continue further inquiry of continue a fresh inquiry. Then also, if that employee before the imposition of the punishment, if you were in suspended condition, then the deemed suspension has to be continued. So these are all the 4 conditions that employee will be under deemed suspension. Followed? If any doubt in this? Any doubt in this deemed suspension? So of course, suspension, no doubt, I know it. But if deemed suspension, if anybody has any doubt, he can ask.
Sir,
No doubt. Okay.
sir, we will, sir,
Yes,
sir,
please.
come back to the same link, sir. This link is getting cut now. We will please come back
Okay.
to the same link, sir. Please.
Okay, thank you. No problem.
I request all of you to please come back to the same link. Please join in the same link again. I am closing this session. New link. Sir, Prabhakar sir, idira. Prabhakar sir. Prabhakar sir. Sir, Prabhakar sir, ಬಂದಿದ್ದೀರಾ sir?
Yes, ಬಂದಿದ್ದೀನಿ.
Okay, sir. We will continue, sir. Others,
Okay.
please mute your microphone. Sir will continue. Yes, sir.
Okay, now we were talking about the
आज है ना 25th है ना और स्टार అన్ని దగ్గరికి వస్తాయన్నారా ఈ రోజే కదా
I hope everybody has joined back. Now we'll continue. I was talking about the deemed suspension. There are 4 types of deemed suspensions. Already I have told you. Suspension I told you. Then suspension is served in the form of SF11. Deemed suspension is SF2, form number 2. Then form number 3 is there. What is this form number 3? Any suspended employee to get subsistence allowance. One allowance will be paid during the period of suspension to the suspended employee. That allowance is called as subsistence allowance. You may get a bit question. Subsistence will be paid during the period of suspension, like that, something like that. Or a deemed suspension will be issued through dash. Or suspension will be issued through dash form. Though here will be SF1, SF2, SF3, SF4 will be there. You have to select and write. Like that, they may ask some questions. So finish. Then further, this subsistence allowance will be paid to the suspended employees. Normally, 50% of your basic pay, leave salary, basic pay in the sense leave salary. During the period of leave, whatever salary you are eligible, in that 50% of your basic pay, leave salary, will be paid as subsistence allowance to the suspended employees. To get this subsistence allowance, the suspended employee has to execute one SF3. What is SF3? SF3 is nothing but a declaration stating that during the period of suspension, I was not engaged, I was not appointed anywhere with gainful salary, like that. He has to declare, I was not employed anywhere I was not getting any salary. Like he has to declare and give a declaration. That declaration is called as SF3, standard form number 3. After getting this standard form number 3 only, giving this standard number 3 only, your bill clerk will prepare the salary and subsistence allowance and will pay subsistence allowance to you. This is subsistence form number 3. Then our friend has asked how long the suspension period has to be continued, and it will continue. Now, normally, suspension should not be continued for more number of days. This is the rule. Suspension should not be continued for more number of days. It is because we are making employee idle. Simply, we are making him to sit, and we will be paying them his salary. That is subsistence allowance. Okay. So to avoid that, as far as possible, the fact find inquiry or investigation or trials or DR inquiry, whatever may be, has to be completed completed soon, expeditiously, and then he has to be put back for duty. That is one thing. If suspended employee is not harm in nature, that means there is no record to be spoiled by him or something like that. So DA can take a call and he can put him back for duty immediately. There are so many instances within a day or two, employees were revoked from suspension. Like that, there are so many things. In some cases, some police investigations will be going on. So especially this corruption cases, bribery cases, the suspension period may be more. Other cases, suspension period will be less. Okay. Trap cases, suspension period will be more because they take more time to conduct inquiries, fact-find inquiries, or DR inquiries, or trials and all. So they may take more time. In any case, every 6 months or 3 months, 90 days, a review committee has to be appointed. Every 90 days, a review committee has to be appointed, and it has to study the probability of revoking him for duty, putting him back for duty. They will study, they will put up so and so. That employee is not cooperating to conduct the fact-find inquiry or DR inquiry. He is simply using his didactic tactics and making us to improve, delay in conducting the inquiry. Under such circumstances, what will happen? His subsistence allowance will be reduced. It may be reduced from 50% to any percent, 25%, 30%, it will be reduced. That is one chance. In other chance, IO or police people, they may not get some material to complete the inquiry. The delay in completing the trials or inquiries or investigations, it is because of the administrative reasons. Then the subsistence allowance may be raised from 50% to 75%. Even if it delay is more, even it may go even up to 100%. There is no problem. It may be given. There is no harm in giving also. That's why in both the cases, if conducting of inquiries or completion of inquiry is because of the non-cooperation or non-attendance of the charged employee, your subsistence allowance will come down and the period of suspension will go up. If it is in vice versa, if the conducting of inquiry or conducting of trials or something, it depends upon the delay of, due to administrative reasons, then the delay, suspension period, of course, it will be increased. But at the same time, subsistence allowance will be raised from 50% even to 75 or 80 or even 100 also. It may go. Okay, there is no harm in this thing. That is one thing about the period of suspension. I think that doubt is clear. Some of my friend has asked that how long the suspension period may be continued like that. One thing over. Now, what are the periods? How the suspension period will be treated after the completion of the proceedings? That I will clear it first. Now, rule says that after the suspended employee after this thing, he has to be issued with only major penalty. That is the rule. Only major penalty charge sheet as far as railways is concerned, SF5, standard form number 5 only to be issued. That is the standard rule. Say, for example, inquiry is conducted, he need not be given SF5. Then the SF11 is given. So that means the intention of the DA is to give only minor penalty. SF11 means only minor penalty only can be given. So when such is the case, the period of suspension will automatically be treated as on duty. When SF11 is given, the suspension period will automatically be treated as on duty, number one. And if minor penalty is imposed, suspension period has to be treated as on duty. No, actually some DS will give, they will give 3 months are censured and suspension, the period of suspension is treated as leave. It is incorrect. It is incorrect as per rule. It is against the rule. When a minor penalty is imposed, suspension period has to be treated as on duty only. Okay? Thing is. Then, coming to the major penalty. Major penalty is issued. And major penalty is imposed. Major penalty charge memorandum issued and major penalty is imposed. Then, what happens? It is the power lies with the DA to decide the period of suspension. He can decide the period of suspension either to be treated as leave or period of suspension to be treated as suspension only, or the period of suspension is treated as normally when suspension major penalty is imposed, it should not be treated as on duty. And because to give some lenience, he may treat as LWP, leave without pay. Like that they will treat. Normally, so far as my knowledge is concerned, when major penalty is imposed, suspension period is treated as either leave or leave without pay or suspended only. These are the three only they have done. On this thing without the on duty, they have not treated whenever major penalty is imposed. Okay, I think this doubt is clear. Okay, now we will come to the what are the pardon.
Does this period affect the pension benefit? जैसे the period treated as a suspended या
I will tell
LW.
you. See, the repercussion of the suspension is whenever you are suspended, that goes to non-qualifying service, NQS, isn't it? NQS means non-qualifying service. The period of suspension is treated as NQS, non-qualifying service. Non-qualifying service will be, it is nothing but a break in service. So that period will affect your promotion. If it is treated as leave, it will not affect your promotion. If it is treated as suspension only, then it will be treated as NQS in your SR, service register. They will mention NQS from so-and-so period to so-and-so period, NQS, non-qualifying service. Therefore, you may represent it to this thing and get it at least as leave. Let that leave go. You, whatever promotions due, you will get promotions. So you have to represent and get it rectified. That is the thing. If DA is good, he may consider your this thing, or AA or RA at any level. They may consider, and anyway, penalty is imposed. He is undergoing penalty. In addition to that, why that is again NQS non-qualifying service to be entered into a RESA? That also you can ask. Okay, clear?
Clear, sir. तनी हिंदियों में सर बोल देते ना, राजभाषा में थोड़ा सा, अंग्रेजी में थोड़ा सा दिक्कत होता है सर थोड़ा.
पढ़न ये हिंदी में बताना.
थोड़ा हिंदी में भी बीच में बोलिएगा ना तो रिदम पे रहे.
लेकिन मेरा हिंदी उतना ठीक नहीं है. आप संभालना.
हिंदी भी बोलिए सर.
No, my Hindi is not that clear. Whatever Hindi I know in that language, I will tell you.
सर टुटले भाषा में बोलिएगा सर, हम लोग खींच लेंगे. टुटले भाषा में बोलिए सर.
अगर सस्पेंशन पीरियड को सस्पेंशन करके लिखा तो DA, वो सस्पेंशन पीरियड आपका एसआर में एंट्री हो जाएगा। वो होने के बाद उसको नॉन क्वालिफाइंग सर्विस करके बताएगा। उस जब भी नॉन क्वालिफाइंग सर्विस होता ना, तब वो आपका प्रमोशन का चांसेस कम पड़ जाएगा। यू विल नॉट बी एलिजिबल, आपको एलिजिबिलिटी नहीं रहता प्रमोशन के लिए उतना पीरियड में। 6-10 महीना रहा समझो, तुम्हारा जूनियर उसको प्रमोशन मिलेगा, आपको प्रमोशन नहीं मिलेगा। आप लीव नॉट ड्यू और लीव LWP और LAP यू कैन आस्क, यू कैन गेट इट कन्वर्टेड। सो आप LAP पूछ सकता, कम से कम LAP दे दिए सर, वो सस्पेंशन पीरियड को करके पूछ सकता, वो कन्वर्ट कर सकता आप। ओके, मेरा हिंदी उतना अच्छा नहीं है, फिर
नहीं
भी मैं
ठीक है सर,
कोशिश करूंगा।
इतना पे ही हो जा रहा है सर, थोड़ा हिंदी भी हो जाता है ना तो उससे
ओके
समझ में आ जाता है।
ओके,
Your
अच्छा,
speech is quite good and understandable. Please continue.
ओके, थैंक यू। नाउ so this period of ho gaya. Now whether leave can be given, whether, see, this is my sincere request, suspended employee should not ask for leave. Actually what it says, suspended employee should not leave the headquarters, there is a clause. But why you want leave? You take permission and go. You take permission and then go, don't take leave. Okay, and then leave also should not be given to the suspended employee because it affects him. His leave will go unnecessarily. If any the supervisor who knows the suspension rules, then he will not say, he will simply, you give me a permission letter, I will take permission and go and come back. Like that they will tell, isn't it? That is one thing. No, don't take leave. Say for example you are sick, then how to think? Then the supervisor has to give a message, then you will be given a treatment. So that period will be under suspension, but you will be given all treatment as if you are under sick list. Sick also, even sick marked also, your sick leave will go, isn't it? So leave, we should not encourage supervisors to mark as leave. That means you should not ask leave, you should ask only permission. That's this thing. And regarding the eligibility of pass and PTOs, pass and PTOs you can take, it is your right. Whether you are suspended or not suspended, you can take leave, but it should be accompanied by the permission to leave headquarters. So your pass will be given whenever you are permitted to leave headquarters. Your PTO will be given whenever you are permitted to leave headquarters. These two are interlinked. These two are interlinked. Otherwise, they will not give. So आपको पास होना तो आप परमिशन टू लीव हेडक्वार्टर्स ले लेना, वो परमिशन का लीव हेडक्वार्टर्स दे दिया तो पास दे सकता, परमिशन टू लीव हेडक्वार्टर्स नहीं दिया समझो, पास दे के क्या फायदा, नहीं देता वो। पीटीओ और पास दोनों, सो दोनों आप दोनों देना, एक रिक्विजिशन टू लीव हेडक्वार्टर्स और एक पास के लिए, दोनों मिलके देना। जब भी उन्हें परमिशन देता ना तब पास पीटीओ दोनों देगा, नहीं तो नहीं देगा। अगर आपका फैमिली जाना चाहिए, आप नहीं जा रहे, फैमिली के लिए पास मांगता, फैमिली के लिए पीटीओ मांगता, तब वो जरूर देगा। देयर इज नो रिस्ट्रिक्शन, ही हैज टू गिव। सो ओनली फैमिली यू हैव टू से, आई रिक्वायर पास और पीटीओ ओनली फॉर माय वाइफ एंड चिल्ड्रन, सो एंड सो लाइक दैट, व्हाट इज फॉर्मेट इज दैट, वो आप लिख के दिया तो वो फैमिली एंड चिल्ड्रन को दे देगा, पास और पीटीओ दे देगा, उससे कोई ये नहीं है, रिस्ट्रिक्शन नहीं है, वो मिलेगा उसको। लेकिन पास एंड पीटीओ आपके लिए चाहिए तो आप क्या लेना, वो परमिशन टू लीव हेडक्वार्टर्स फॉर दैट पीरियड यू हैव टू टेक। मैं इतना दिन मुझे परमिशन टू लीव हेडक्वार्टर्स चाहिए, मैं घर जाके आऊंगा करके लिख के पास और पीटीओ भी पूछना, वो दे देगा, वो आपको परमिशन भी मिलेगा। सो देयर इज नो रूल, देयर इज नो रिस्ट्रिक्शन टू गिव पास एंड पीटीओ। ओके, हियर और एक क्वेश्चन है, whether the suspended employee can act as a defense helper. Whether suspended employee can act as a defense helper. Say for example, suspended employee का बहुत नॉलेज रहता, वो दूसरा आदमी का डिफेंस करने के लिए उसको बहुत ताकत है, उसको नॉलेज है। So whether can he be permitted? Yes, he has to be permitted and he will be permitted. So उसको टीए भी मिलेगा। So अभी जब भी चार्ज एम्प्लॉई, say for example Prabhakar Rao, suspended employee, I want Prabhakar Rao to be attended as a DH, then he will be permitted. So the supervisor will permit him, and to go and come, pass also will be given, and for having made this journey, TA also will be given. TA also will be given. So there is no harm, there is no restriction for acting suspended employee as DH, defense helper. Okay, understood? So you can, there is no restriction for that. पास एंड पीटीओ दे सकता, डिफेंस हेल्पर ले सकता, आप कहाँ भी इंक्वायरी अटेंड किया समझो, इंक्वायरी के जाके आया आप, डिफेंस हेल्पर नहीं, charged employee, sorry, suspended employee has attended inquiry at some other place other than beyond 8 kilometers, then TA भी दे सकता, TA भी देना पड़ेगा. As per the rules, he should get TA also for having attended the inquiry, DR inquiry or police trial or anything, investigation or anything, whatever he may be. If he attends, he will get the TA also. That he will attend under suspension only. Some people till the completion of the DR inquiry will be under suspension. So under such circumstances, so the inquiry will be fixed at other place other than the headquarters of the charged employee, that is a suspended employee. So he will get everything as that of a regular employee. Suspended employee will get every, suspended employee को सब कुछ मिलेगा, TA भी मिलेगा, वो उसको पैसा भी मिलेगा सब, if it is beyond 8 kilometers as per the eligibility. Okay, so लीव हो गया, डिहेंस हो गया, और ये सब भी मिलेगा. हॉस्पिटल को जाके ट्रीटमेंट भी ले सकता और डिफेंस भी कर सकता. He can act as a defense helper also. Okay, then what, any other things you want to ask?
Hello,
Yes,
sir.
sir.
Good evening,
Yes,
sir.
please.
Myself, Kiran, sir, from Delhi Division. I want to ask a question. Sir,
Please.
what is the difference between dismissal and removal from service?
Oh, very good question. See, removal and dismissal both are major penalties. Number one, अगर employee remove किया तो he can seek other jobs either in the state government, central government or quasi government. आपको बहुत अच्छा ये है, पीरियड है अभी जाने के लिए, सर्विस है करने के लिए, गवर्नमेंट जॉब के लिए जा सकता, स्टेट गवर्नमेंट के लिए जा सकता और क्वाजी गवर्नमेंट के लिए भी जा सकता. रिमूव्ड एम्प्लॉई. डिसमिसल एम्प्लॉई, he is not eligible for any job either for the state government or in the central government or in the quasi government. This is the only major difference. Dismissed employees, they are not eligible, they are unfit to again apply for other jobs either in the state government, central government or quasi government, whereas removed employees, they can apply and get absorbed into other state government or central government or quasi government jobs.
Okay,
Madam,
sir.
clear, madam?
Yes, sir. Thank you so much, sir.
Then one more here I will tell you. Anyway, because this punishments has come, many of the DAs, while imposing the penalty, this removal and dismissal, they have to say charged employee has been imposed a punishment of removal from service with immediate effect with, this is the important thing, with compensatory allowance or without compensatory allowance. With or without compensatory allowance has to be mentioned. Even in dismissal also, the employee has been dismissed either with compensatory allowance or without compensatory allowance. These things has to be invariably a penalty order should carry. Okay, I don't know whether I have told it in my previous class or not. Anyway, situation has come, now I have told. Okay, now the penalty order should contain the employee has removed from service with or without compensatory allowance. The employee has been removed from, dismissed from service with or without compensatory allowance. This has to be mentioned. Here, one more thing I will tell you. Some 5 years back, Railway Board has given a letter. If any such cases are there, when order does not carry, that he is removed from, simply they will say he is being removed from service. Under such circumstances, that particular charged employee may ask for compensatory allowance, and if whatever may be the oldest case, even 20 years back also, if he is removed, so case may be reopened. And if case file is available, DA who has imposed the punishment, he may reopen the case file, and if he feels that he can consider and grant him compensatory allowance, just up to one third of his last pay drawn may be given to him, isn't it? So this point is very, very note. Anyway, thank you, madam. You have raised this question. This point, so many cases. After this thing, old cases we have dug out, and employees got the compensatory allowance because of this point. Railway board circular is there. And then I will post this railway board circular to Balaji sir, and then he will transfer it to you. So after this session. So
Yes,
this
sir.
circular, pardon?
And sir, what will be the effect on pension, etc., in the case of removal and dismissal?
Pension ka matlab, they will not call it as pension. They will call it as compensatory allowance. Some people, out of ignorance, they may call it as pension, compensatory pension. It is not compensatory pension. It is called as compensatory allowance. It is eligible for removed and dismissed employees. The penalty order should contain whether the employee has been removed from service with or without compensatory allowance. If order is simply removed from service or dismissed from service, then case can be reopened. And employee may ask, you have dismissed me, all right, sir, at least make me, give me some livelihood. You sanction me compensatory allowance. Like that, employee may ask. Okay.
Sir, can
this even oldest cases also can be, pardon?
Sir, can this compensatory allowance be 100%?
No, it is only 1/3, I told, no?
Maximum of 1/3.
Yeah, maximum 1/3. Okay.
Yes, sir. Any other questions? Anybody else?
Yes, sir. Yes, sir. Yes, sir. मेरा है सर.
बोलिए सर.
सर किसी भी सीओ का केस अगर एज ए डीएच हम हैं किसी अदर स्टेशन पे, तो हमको वहां से स्पेयर करने के लिए इंफॉर्मेशन देना या वहां से पास निर्गत हमको कौन करेगा? डीए ऑर्डर करेगा या आईओ करेगा?
No, I could not understand. Please tell me your answer, question again.
I am DH in a D&AR case.
Okay.
And I have to attend inquiry at another place, and the CO residing at another place, or the inquiry has to be conducted on another place.
Yes.
So who will provide the instruction and the guideline to spare me from that station and to give me the pass or the other benefits to conduct the inquiry? DA or IO?
Okay, very good question. Thank you. This is very, very important question also. See, IO, it is the duty of IO. CO has nominated you as a defense helper. Correct? Then, when you have been nominated as a defense helper, it is the duty of the IO, inquiry officer, to call you for attending the inquiry as a defense helper. Number one. Number two, along with the inquiry notice, it is the duty of IO to send you a pass from your place of your headquarters to the inquiry place and back, to and fro pass he has to give. In case if he is not in a position to give a pass for to and fro, then he has to advise your supervisor under whom you are working to issue a pass for to and fro journey, and also to relieve you to attend inquiry as a DH to that place. Understood? And once if he is there, as usual, you have to submit your TA journals to your senior DPO stating that I have attended inquiry, that inquiry letter, inquiry notice you have to enclose, and then you can claim TA also for that. Clear, sir?
Clear, sir.
Any doubt you can ask. This is a very good question actually. So many people will not be aware of that.
Sir,
Any other questions, please?
Yes, sir. Can we talk about major and minor penalties in this class, or can we have another class? What are major penalties, minor penalties?
We can, sir. Major penalties.
Last interruption, sir. Last interruption, sir. Sorry. Last interruption, sir. Can your supervisor make you hold to attend the inquiry? जैसे आपकी इंक्वायरी है, आपका सुपरवाइजर है, इमीडिएट बॉस क्या आपको रोक सकता है अगर कोई अर्जेंसी है या कुछ ऐसी जरूरत है तो?
Though he can stop you from attending the inquiry, giving a suitable reason. He is required for another inquiry here, so his attendance will not be made available. Hence, inquiry may be postponed like that. He has to write a letter to the inquiry officer, and a copy has to be given to you.
Thank you, sir.
Simply नहीं कर सकता, लेकिन proper speaking orders has to be given.
Thank you, sir.
Sir, one more question, please. Sir, one more question, please.
Yes, please.
Like if a defense helper is a retired railway employee, then also it is the duty of the IO to provide him with the pass, or he will arrange it on his own?
No, whenever retired employee is nominated as a defense helper, and if IO has accepted him as a defense helper, it is the duty of IO to see that a pass is issued to him for to and fro his journeys. And he can also submit his TA journals to the place where he got retired. Say, for example, Bangalore division, if he is retired, he has to submit his TA journals to Senior DPO Bangalore and get a TA also for that.
Okay, sir. Thank you.
Any other these things? Now, one more thing I was saying, if any employee is under police custody for more than 48 hours, it is the duty of the that particular employee to inform his controlling officer that he is under police custody. For example, he was not in a position to inform him immediately. Then after this coming out either from the bail or from this thing, he has to write a letter to his branch officer or controlling officer saying that I was under the police custody from so-and-so period to so-and-so period. If he is not intimating, in addition to the other charges, this also for not intimating also will be one of the charges in the charge memorandum. So therefore, always it is better the suspended employee has to inform his controlling officer that he was under police custody for so-and-so period to so-and-so period, at least even after getting released on bail. After releasing from bail, he has to submit like that. Any other these things?
Good evening, sir.
Good evening, tell me.
I want to know what is the meaning of speaking orders?
Speaking order, very good. This actually, speaking means what? For a reason, say for example, employee has remained absent. Example only I am telling. Employee has remained absent from so-and-so period to so-and-so period. Charge sheet was given, and while imposing penalty, a speaking order has to be given by the DA. Then what should be the form of the speaking order? First, DA should say that the charge sheet was given for so-and-so purpose. He has remained absent for so-and-so period to so-and-so period. And charge sheet was given for remaining absent for say for 39 days or 40 days he has remained absent without obtaining prior sanction of the leave or without obtaining prior permission, which is against the rule number so and so. Hence, I hold him guilty of the charges. This word should come. I hold him guilty of the charges leveled against him. That is number one. Number two, suppose that means up to that part he has written correctly. Then further, the strength that means how much penalty has to be imposed. For that, he should say his remaining absent has caused, interrupted the smooth working or working, safety working, and also involved in the payment of DA. I mean, OT, and if TA is involved, TA, and caused heavy loss, and it is not possible for other employees to get leave. Therefore, that means all the reasons why he is coming to such a situation to impose that penalty, he has to write. That means the speaking orders are his remaining absent has caused unrest among the staff, has resulted in the payment of OTA, has affected the safe working of the trains, like this. Therefore, such people should be imposed with this thing to learn him, teach him a lesson. So I impose so and so penalty, like that he has to write. So speaking order, in short, your orders must give reasons for imposing such penalty. The penalty. First, you should hold the charged employee guilty of the charges. That is one. And second part is imposing the penalty. These two parts must be there in the speaking order. First one is holding him guilty of the charges, whether he is guilty or not, whether the charges leveled against him correct or not, proved or not. If proved, how proved? He has to say the master particulars shows that he has remained absent, and pay particulars, if anything is there available in the this thing, so and so was not paid any amount of salary for so and so period. Therefore, it is proved that he was absent. Hence, I hold him guilty of the charges leveled against him. Therefore, I impose the penalty. For imposing, then what is the repercussion of that absence? That repercussion of that absence is resulted in the unrest among the other staff. Other staff could not get leave because his absence, and in addition to that, OT also was paid. Therefore, I impose the so and so penalty, like that. Yes, right. This is the speaking order. Any other these things?
Sir, that is what.
Sir, in that case, the annexures, 4 annexures also will be given, no, sir? So the first annexure is relating to the speaking orders?
See, there are 4 annexures in the charge memorandum. First is the articles of charge. Second one is the statement of imputation in support of the articles of charge. Third one is the statement, the listed documents based on which the charge memorandum is based. Then fourth is the listed witnesses. Listed witnesses based on whose deposition the charges are going to be proved or not proved, isn't it? So these 3 only to establish the charge, isn't it? Whenever charge memorandum is prepared by using these things, it is not the speaking orders. DA has to prepare all those things. He has to say whether charges proved or not proved. If it is proved, he has to discuss the evidences, whatever is there in the inquiry, evidence adduced in the inquiry, and he should write reasons for the findings, and then lastly he has to say findings. Isn't it? In my previous class, I told 9/25, rule number 9/25. It says how to prepare an inquiry report. How to prepare an inquiry report is given clearly in the rule number 9/25. So based on this inquiry report only, so DA has to take out the things. He should not bring anything outside from his mind or outside from his knowledge. Whatever available in the inquiry report, whatever available on the record, from that only has to prepare and write. Okay. Understood, madam?
Yes, sir. Thank you, sir. Thank you.
Okay.
So, sir, can we go ahead with major and minor penalties, sir?
Sir, major and minor penalties, I can go ahead, no problem. But thing is, what are the repercussions of the minor penalties or 4 minor penalties, and what are the repercussions of the 4 major penalties also to be discussed?
Okay, sir.
Only minor
penalties.
Okay. Both we have to say. If say, for example, censure is imposed. Censure is the most minor penalty among the major. See, rule number 6. Rule number 6.
Sir.
Yes, sir.
Sir, again, session is getting closed. We will come to the new session and then discuss minor penalty, sir, please, for 1 more hour.
Okay, no issue, sir. We will discuss.
Okay, sir. Okay.
We will discuss, sir.
Everybody, please come back to the meet in the same link. please come back to the same link. Yes, welcome back everybody. I'm really sorry this 5 minutes thing is there.
ब्लैक ब्लू में दिया उससे अच्छा ये नहीं लग रहा है
It sounds like you're frustrated after.
लेकिन नहीं हम देख हम ब्लैक और ब्लू दे रहा था तो ब्लैक ब्लू इसका फिटिंग अच्छा है
ये जैसे होता हो
हाँ हाँ
सर प्रभाकर सर ಪ್ರಭಾಕರ್ ಸರ್ ಬಂದಿದ್ದೀರಾ?
ಬ್ಲಾಕ್ ಬ್ಲೂ में दूसरा कलर में सेम फिटिंग
Okay, so I think sir has not joined yet. So yeah, how is the class? Are you? Do you feel that the classes are good? Anybody has any opinion about it? Okay, sir, welcome back. Prabhakar
Sir. Okay, thank you, sir. Sir, before going to that minor penalties, if any doubt is there, let them clear all the doubts, sir.
Anybody has any doubts, you can ask on any topic about this, what we are discussing.
Because somebody,
Sir, one doubt, sir.
Somebody raised very good doubts. Tell me.
Please ask your doubts. Anybody has a doubt, you can please ask.
Sir, am I audible?
Yes, you are audible. Please ask your doubt.
Sir, regarding that issuing the pass, if employee is at defense helper,
Hello.
that time if the person is residing in his native, so from where he can get a pass, sir? Whether it is from the retired place or whether it is from the native place.
See, I have clearly told it is the responsibility of the inquiry officer to issue him the pass. Along with inquiry notice, anyway, he has to send inquiry notice to attend inquiry to his native place. So he has to take a pass. So, for example, if inquiry officer is commercial inspector in Bangalore division, so he has to write a letter to senior DPO, get one pass, then enclose that pass along with the inquiry notice. Then that pass has to be sent along with the inquiry notice to the defense helper.
So it means that it is from the place where he is residing. From there only he can commence this thing.
No, that is from where. That means from the place where residing to inquiry's place, and then back to his residence. Say, for example, I am residing at Delhi, so I have to attend inquiry at Bangalore. Then that inquiry officer has to give a pass from New Delhi to Bangalore and back from Bangalore to New Delhi. In the class which I am eligible, when I was retiring, at the time of retirement, whatever I was eligible, that class only to be given. If I am eligible during the time of retirement, if I am eligible for AC class pass, or sleeper class pass, like that.
Okay, thank you, sir.
Cleared?
Yes, sir, thank you.
It is the duty of IO. It is the duty of IO, inquiry officer. He has to make all arrangements.
Any other
Okay,
doubts?
sir, thank you.
Any other doubts? Anybody
sir,
can ask.
Sir, one doubt was there.
Yes. Pardon?
Whether this defense helper is eligible for TA transportation allowance?
Yes, 100%. See, when he is attending the inquiry, Say, for example, from Delhi, I have come to attend inquiry to Bangalore. So, Bangalore, whatever that A class city alliance TA, I will get it. He is eligible.
Okay, sir.
Okay. Then,
Any other questions? Anybody is open to ask questions. Whatever questions you have, you can ask, please.
So one question with regard to if an employee who has been under deemed suspension, and after he is released from the prison, does he have any number of days within which he has to report to the controlling officer? One second.
no, sir, it is not like that reporting. He has to immediately report. Otherwise, the period will go as this thing. No. Now, as soon as released, he has to come back and report to the his controlling officer for his normal duties. If he is sincere enough, he has to give a letter stating that I was in police custody from so and so period to so and so period, and I was released on bail, and now I am reporting. Now, basing on that, he will be kept under deemed suspension. If advance information is received before he could tell, then right from the time of his custody, that he is deemed that he is under suspension. Otherwise, when he reports from that time we are receiving, so dating back from so and so period to so and so period is deemed as suspended. He has to come immediately, sir.
In the case where the police informs the department and he is kept under deemed suspension, later on he is released on bail. He is released, and within how many days and what is the steps he has to take to come back to duty, because he continues to be under deemed suspension. Is there any time limit for that?
Sir, as it is deemed suspension, and suspension for other conditions are same. He should report back, and he should he should not leave headquarters. Though he is under deemed suspension, he should not leave headquarters without the permission. Conditions are same for both the suspension and deemed suspension. If you want to leave headquarters, he has to take permission and go. Even deemed suspension also. And whenever he is released, it is his duty to report back immediately. Immediately has to come back, sir. If any traveling time is there, if any traveling journey time or traveling time is there, that he can say, I have taken so much time to come back from here to so and so.
Right. In the case, in the event the employee after release has not reported and continues to be not available at office also, what needs to be done?
For that again, you have to include one more articles of charge while framing the charges, sir. Though he was you were discharged this thing, you have not attended this office, so you have not attended from without obtaining the permission. You have left away from. You are not reported here, so it amounts to leaving headquarters without permission. That will add up to the articles of charge, sir.
Sir. The other issues in the case where he doesn't come to report, and neither his whereabouts are known. Is it compulsory for the employee to attend his last office every day during the period of suspension?
Sir, he need not attend the office every day, but he should not leave the headquarters without permission. That is the rule. Rules of suspension says he should not leave the office without his permission. Permission of the supervisor or controlling officer.
Sir.
Okay.
Any other questions from anybody? Shall we go for penalties, minor penalties? Sir, please, sir. Can you please?
Yes, sir.
Okay, sir. Hello? Somebody was telling something in between?
Sir,
okay.
Please.
Okay. See, the penalties are available in rule number 6 of D&AR. Those two penalties are called as minor penalties and major penalties. Minor penalties are 4 in nature. Only 4. The first and foremost penalty or minor most, you can call it as minor most penalty also, because sometimes they will ask one bit question. The minor most penalty is dash. Minor most penalty is dash. Sometimes they may ask dash, or sometimes they may give options also. What is the minor most penalty? So minor most penalty is censure. What is meant by censure? Censure is nothing but warning, but it will be entered into SR. It will be entered into SR, number 1. So then, how this will affect your promotional opportunities? Censure will not come in your way of promotion. Censure will not come in your way of promotion. If you are due for promotion, 100% promotion can be given. So promotion cannot be delayed or kept pending, because that a penalty of censure is imposed. Okay. Then withholding of promotion for a specific period. Withholding of promotion for a specific period. This sentence itself says withholding of promotion for a specific period. So that means this is going to affect your promotional opportunity. Okay. Now here, one more funny thing. Now, for example, say, for example, the penalty is imposed with in a withholding of promotion for a period of 6 months is imposed. Then during that 6 months period is not eligible for promotion. What is the use of imposing that penalty? Isn't it? Some people have imposed that penalty. That penalty is imposed, withholding of promotion for a specific period. So then during that period of 6 months, he is not eligible for any promotion. He is junior most, all seniors only are there. So he is not getting any promotion. Why I am telling now, the DR dealers are very, very, I mean, what I can say, intelligent people. They advise the DAs, sir, this penalty we can give. DAs, okay, this looks to be very simple, this thing, dangerous than this thing. But DA will not be knowing when this fellow will be due for promotion. All these things the DA will not be knowing. So immediately what he will impose that penalty. So then that penalty, what it says, it will not have any effect, negative effect. So there the employee will be saved. So red ink entry will be there. That withholding of promotion for a specific period. So promotion will not get. So they will not have any effect. Then withholding of recovery of pecuniary loss caused. Recovery of pecuniary loss caused due to the negligence of the employee, either in full or part thereof. See here, this penalty actually, that this thing DA while imposing, you should know why he is imposing this penalty. Then only he can impose this recovery withholding of recovery of pecuniary loss caused will not come in the way of promotion. Recovery of pecuniary loss caused will not come in the way of your promotion. How? Because the amount, so much amount he has to be recovered, so penalty closed, ended. That is open and closed system, isn't it? So you have imposed the penalty, amount is recovered, so there ends the penalty. So therefore, if he is eligible for promotion, he will get the promotion. So it will not affect your promotional opportunity. Then how much to be recovered? That is the problem. Normally, this penalty will be imposed in group, whenever a group of employees are involved in this thing. So the total cost will be taken into calculated, and it will be divided among the all persons. Then they will share this cost, because otherwise, say for example, some accident case, some 5 lakhs 6 lakhs loss is there. So if 5 lakhs or 6 lakhs is put only on one person, it will be heavy. So all different departments will be there. commercial department, operating department, engineering department, S&T department, all these departments are involved and held responsible for that particular accident. Then this amount will be divided among all these employees. Say five employees are there, so all these employees, and it is not mandatory that full 5 lakhs to be recovered. So say for example 2 lakhs or something to be recovered from all the 5 employees. So it will be divided, and 4 employees and 50,000 or something like that, that they will recover. So this amount, this penalty, recovery of pecuniary loss caused by the employee due to his negligence, either full or part thereof, will not affect your promotional opportunity. Then withholding of pass, PTO, or both. Here there is a comment on this. Withholding of pass or PTO or both. Somebody say, either you withhold my pass, don't withhold PTO. If you are doing both, then it is nothing but, what is that? Double jeopardy. That means 2 penalties you are giving. So as far as the man who knows the DR, they say that it is not 2 penalty, it is only 1 penalty. The penalty says withholding of pass or PTO or both. Withholding of pass or PTO or both is only 1 penalty. So it will not amount to double jeopardy. Therefore, this penalty is not double jeopardy penalty, it is only single penalty. And then whenever this penalty is imposed, it will not affect the promotional opportunities. It will not affect the promotional opportunities. Okay. Now, what is other penalty? Bringing down by 1 stage. Bringing down by 1 stage for a period of 3 up to a period of 3 years. 1 stage for the year. Here I will let you know what is the stage. Of course, you know it. Just simply for clarification side, I'm telling. Stage means 1 increment. Stage means what? 1 increment, annual increment. Bringing down by 1 stage for 3 years is a minor penalty. Up to 3 years, not exceeding 3 years. They say not exceeding 3 years. They say not exceeding 3 years. Say 3% of increment, 3% of your basic pay will be reduced. But that means 3 plus 3 plus 3, 9% will be reduced. Isn't it? So it will be bringing down one stage for 3 years is up to 3 years.
1,000 में दे रहा है बोले तो ले लेते थे.
Pardon? Up to 3 years. Okay. Then this thing. This, see, this will affect your promotional opportunity. Actually, whenever reduction in stage is imposed, a penalty of reduction in stage is imposed, then that means it will have immediate effect. Reduction in stage or grade is in the major penalty. Reduction in stage will have immediate effect. So rule says whenever an employee is undergoing penalty, see in all the previous cases, censure, open and close, then recovery, open and close, then withholding of pass and PTO, open and close. Here recovery, reduction in stage. Reduction in stage is continuous process. Here he has reduced his basic pay by 1 stage for 1 year, 3 years, or 6 months. During this period, if he is eligible for promotion, so he will not be eligible for promotion till the time he clears the penalty. Till the time he clears the penalty. This is how the penalty is going to have an adverse effect on his promotion. Understood, sir? Whenever an employee is undergoing a penalty, kindly underline, undergoing penalty, he is not eligible for promotion. This has to be kept in mind. Undergoing penalty. Whenever an employee is undergoing penalty, he is not eligible for promotion till the time he clears the penalty period. Okay. This is how this affects this reduction in stage or reduction in this thing, reducing in stage by one stage will affect your promotional opportunities. Okay. One side,
Sir.
this is second time, thus penalty is, you are not getting the promotion. Sir, Chapan sir.
Sir, 2 questions. One, This one says 3 years. 3 years
Yeah.
means 36 months or 35 months.
Sir, this is up to 3 years, not beyond
Yeah.
that.
So that means
Even we
up
can
to
give
36
36
months.
also. Yeah, up to
Okay.
36 months you can give.
Well, then that is one
See,
issue, because some
yeah.
divisions adopt that
Some
up to
says
35
that
months is minor.
to avoid the complications, they will give 35 months.
Exactly. Second issue,
Yeah.
with regard to the you're talking about the promotions, that he is not eligible for promotion till once he completes completes the penalty period, will he be put back
Yeah.
to the original position?
Definitely, sir. See, on completion of the penalty, he should bring back the whatever increment reduced, it should be given back to him, and then promotion has to be affected. His seniority has to be restored. Whatever seniority he holds previously, even if junior got promotion and surpassed him in this thing, so on completion of the penalty period, he will get promotion. Only during this period, he will be having the financial loss. He will suffer only financial loss. Say one stage, one increment means 3% plus DA plus TPT, CCA multiplied by 12 months. That is only loss. Otherwise, on coming back on completion of the penalty, he will be promoted to that this, and his basic pay also will be restored, and he will be promoted.
Sure, sir.
Clear, sir?
Yeah, fine, sir. Fine.
Okay. Now we will come to that fourth penalty. What is that fourth penalty? Fourth penalty is withholding of annual increment. Withholding of annual increment. Here, one more point I wanted to clearly tell you. Here, one terminology is there: recurring and non-recurring. All minor penalties are non-recurring in nature, without cumulative effect. Recurring and also without cumulative effect are one and the same. I will tell you what is the recurring and the non-recurring. Say here, our sir has asked, on completion of the penalty, he will be brought back to his original pay scale, whatever recovered, it will be given. That is non-recurring. He will undergo only financial loss. That means, say for example, 3% plus DA plus TPT plus CCA multiplied by 12 months. That 1 year he will undergo loss. And on completion of the penalty, he will come back to his original basic pay, and then from there he will carry in his promotion or increment. If he gets, he'll get increment and go. In case of non-recurring, means recurring or cumulative, this will not, he will not get back this one increment. This one increment is totally lost to him for 1 year. That means his 1 year service will be treated as non-qualifying service because of this recurring punishment. It comes only under major penalties. So simply, I have cleared the doubt here. So recurring and non-recurring, and cumulative or non-cumulative, both are cumulative or recurring, both same, and non-recurring and without cumulative are one and the same. Okay. Now he will get back these thing increments. He will his pay will be restored if it is non-cumulative or non-recurring. Then he will get the increments further. This is the difference. So he will have only financial loss during this period of punishment. Okay, that's this thing here. And then this reduction in grade, reduction in stage will have immediate effect. That is, immediately it will play its role. So if he is due for promotion, so he will not get the promotion when this is imposed. Then withholding of annual increment, withholding of annual increment for a specific period, without having adverse effects on pensionary benefits, either cumulative, I mean with non-cumulative. This is the another penalty. Here he has to mention a specific period. The penalty has to be mentioned for a specific period. Say for example, your annual increment, rising pay from so and so in scale so and so. is withheld, normally due on so and so date, is withheld for a period of 6 months, say 3 months, up to 3 years. Up to 3 years, not beyond 3 years. So some people will give only up to avoid complications, 35 months they will give. So up to 3 years, not beyond that. Then here, what will happen? Withholding of annual increment, which is not, say for example, no penalty is imposed in the month of January. January today is 25th, the penalty is imposed. Here the speaking orders will be right like this. Your pay rising from say the 3,000 to 4,000 in scale, level 1, in a level 1 is withheld for a period of 1 year, for a period of 1 year, which is normally due on 1/7/2025, is withheld for a period of 12 months, 1 year. Like this, the speaking orders will be there. Then here he will not get this increment. He has completed 365 days on 1/7, 36 he has completed, 1/7 is due. So this increment he will not get. So he will get this increment on 2026. That is 1st July 2026 he will get this increment, and also one more increment. 2 increments at a time he will get during 2026. So this is called non-recurring penalty. And if it is recurring, he will get only 1 increment, and during 2026, 1 increment he will not get. This is called recurring and non-recurring. Here, what is the difference between bringing down by stage and this withholding? Means bringing down stage will have immediate effect. Today, 25th January penalty is imposed, will have effect from 25th January itself. Here, same penalty is imposed, withholding of annual increment. So it will start from 1/7, not from 25th July. 25th January. Because normally due on 1/7 is withheld. Up to that prime, this is January 25th to 1/7 is not undergoing any penalty. Kindly note, this point is very, very important. Kindly note this point. 25th January to 36th June, he is not undergoing any penalty. He is free from penalty. Penalty is imposed, but not undergoing. This will have effect only from 1/7. Therefore, during this period, if he is eligible for promotion, if he has to be promoted, you can promote him. No problem in promoting during this period. 25th, say for example, 2nd February, he is due for promotion to be given. You have to give him promotion. There is no problem in that, because he is not undergoing penalty. He is not undergoing penalty. Okay. Then, for example, if he is due for promotion in the month of August, then you cannot promote him because he is undergoing penalty, because from 1st July onwards penalty started. So whenever an employee is undergoing penalty, promotion should not be given to him. Promotion should not be given to him. So you can promote him and affect this penalty in the higher grade. Affect the penalty in a higher grade. Here penalty, here after this thing, he will not at all get promotion till the time he completes the penalty. Followed, sir? Any doubt in this? Because this is a little bit tricky here. Undergoing penalty or yet to undergo penalty. Any doubt, sir? These are the 4 minor penalties.
So the role of the DAR clerk is very important. If they foresee
100%, sir.
they foresee
Sir,
they can save the employee from
yes, sir.
by instructing the DA to give like that.
Yes. Not only that, sir, there are so many things. If you want openly, I will tell. He will keep the file pending. He will not put up.
Okay, sir. So
You will not put up for the clearance. After getting his promotion, only you will put up.
okay, very nice, very good, sir. This is a very nice thing.
I have seen so many cases, sir. I have seen plenty of cases. So that's why I'm telling the dealers of DR, if they are pakka in rules, they can make and mar the CEs, charge employees. They can save the charged employee. They can kill also the charged employee. They can play with the charged employee's service. So that's why I'm telling the dealers of DA should be pakka in D&R. While putting up the case also, sir. While how the case file should be, he should the dealer should put up a charge memorandum was issued to the charge employee on this thing stating so and so charges, which is available at folio number so and so. Like that, they have to write. Further, in response to the charge memorandum, reply has been received. In reply, he states like this, which is placed at folio number so and so. The charge employee says like this. The reply is like this. Reply is not accept something. Yeah, she has to write. He or she has to write like this. So he is not accepting the charges for so and so reasons, and for just sufficient reasons, penalties which can be imposed is kept under folio number so is at folio number so and so. So the DA is requested to peruse the charge memorandum, reply given, and the penalty order, and give the speaking orders. Like that, she has to connect and write. He or she has to connect and put up. This is the way how a DR file has to be put up. But I have seen how the present dealers are putting up. Charge sheet as so and so, reply received is so and so, put up for speaking orders. That's all. Like that, they are putting up. And DA, if he goes through everything, it is all right. Otherwise, DA has to depends upon the supervisors on whom he is having faith. This is all, sir. Anything, sir?
Is the speaking order a must in minor penalties also, sir?
Sir, for everything, speaking orders is a must, sir. Simply some DS will give. I am not accepting the reply given based on so I impose the punishment, which is totally wrong. If he is not accepting, he should say, I am not accepting there is no substance in the speaking reply given by the charged employee for so and so reason, and I hold the charged employee guilty of the charges for so and so reason. First, he has to hold the charged employee guilty of the charges. So then only penalty will, imposition of penalty will come. First, he has to hold the charge guilty, then penalty can be imposed. Like that, sir. Speaking orders for each and everything is kind of must, sir.
Sir, if there is a mistake in this and we go to CAT or court on technical grounds, can this charge be shattered out? Technical grounds.
Yes, they can they will crash, sir.
Okay.
In recently Bangalore case only, I will tell officer's case, I will not take name. One doctor was given a charge sheet. Then there was only technical mistake. Charge sheet was signed by the lower rank than the doctor. Recently in Bangalore CAT, the crashed the charge sheet. Crashed the charge sheet, sir.
Sir, after the quashing, for the same charges, a new charge sheet be issued.
If court gives orders like that, sir, if some court gives orders like that, they can give.
Otherwise, sir, is it not?
Sometimes court gives orders, sir. What they give, no. The charge sheet, which is this thing, at quashed on technical grounds. However, the respondents are free to issue a fresh charge sheet. Like that, they will give.
Okay.
It all depends upon the court gives, sir.
Okay.
If it does not go to the court, then sir, then whether the technical this one can be the charge sheet is down and reissued.
I will tell you, whenever a DA imposes the penalty, then appellate authority is there, sir. Appellate authority has to go through the case file properly, and then he can himself judge. But we have to give complete feedback how the charge sheet is incorrect, what are the lacunas in the charge memorandum, and what are the lacunas in the speaking orders of this thing, how the speaking orders are not correct. Then we have to tell all these things to AA. AA can take call and he can decide, sir. We need not go to court. AA himself can decide it.
Okay. Right.
If AA is not, RA is there. RA can decide it.
In case, sir, as you said, that the case of a doctor in Bangalore, where the junior doctor had
junior
issued the charge
employee.
memorandum. If it is come to the knowledge of the DA, can it be withdrawn and reissued on technical grounds?
On technical beginning itself, they should have done it, sir. Beginning itself, they should have done it, and they have put it. Actually, deputy director has issued, railway board has issued the charge memorandum. The charged employee was a MS. She was more, higher in rank than the deputy director. Okay, so the charge could not stand.
Excuse me, sir.
Charge sheet could not stand. Yes, sir. Yes, ma'am.
Can dismissed employee be reinstated?
Yes, dismissed employee can be reinstated. No problem in that.
On whose order?
Now, who has dismissed him? Who has dismissed him? Whether the DA has dismissed, who has dismissed? DA only no. DA only dismissed no. Sir, disciplinary authority, the person who has issued charge memorandum has dismissed no. Correct, no?
Ranjay Kumar.
Appellate authority can reinstate him. If AA confirms the penalty, RA can reinstate him. No problem. He can be reinstated, sir.
Okay, sir. Sir, only 3 more minutes remaining. Shall we go session, sir, or shall we go again?
It is left to you, sir. No problem. Otherwise, we will discuss it on some other day. It should not be too much.
Okay.
Anyway,
Sir.
you give those 3 minutes to ask questions, sir.
Only 3 minutes are there. Any questions anybody can ask?
Sir, this disciplinary and appeal rules is applicability, sir. Applicability is somewhere in railways. So many members is coming from IRS.
It is not
that is
UPSC. Okay, DNDR is not applicable to RPF staff, UPS that class 1 UPSC in the selected UPSC staff. Then these substitutes and all casual laborers, this is not applicable. Casual laborers, it is not applicable. RPF, it is not applicable. RPF, they have their own their own laws.
They were recruited through UPSC mode. They are also DNRs are applicable to them.
They got their own this thing. They are applicable. It is applicable to them also.
Any other questions? Okay.
We have given charge sheet recently, no?
Sir, thank you very much. Thank you very much for the very nice session, sir. We will.
Thank you, sir. Thank you very much for giving me this opportunity, and I must be thankful to all. Okay, sir. We will discuss the repercussions.
We have to take more questions also. Thank you very much, Prabhakar, for sparing so much of your valuable time, and thank you for all the attendees for having attended and gained knowledge in this. Thank you, one and all. We will see you again in more sessions very soon. Thank you, sir. Thank you all.
Thank you very much.
Sir, namaste. Thank you.
Thank you, sir.